The Second Amendment only protects weapons that are in common use for the purposes of self-defense. This opinion is so unbelievably bad that it actually may have a silver lining for us. We'll talk about that in just a couple of moments. Now, before we begin, this video is sponsored by USCCA, and they're doing a giveaway right now. You're absolutely encouraged to participate. You can find out all of the details below in the description to this video. In today's video, we're going to be talking about a new opinion that's been handed down by the California Third Circuit Court of Appeals in a case called People v. Bocanegra. Now, this decision on first blush looks very, very bad for us as it relates specifically to so-called assault weapons and upholding the idea that California, and for that matter, other jurisdictions, can create all sorts of rules restricting individuals to be able to keep and bear arms as it relates to things like AR-15s. Based on the narrative that the judge articulates of what this particular defendant did, it was some pretty egregious conduct. Won't go through the entire fact pattern, but suffice to say there was infidelity involved with his wife, with his friend, it looks like in both directions, and this ultimately resulted in the defendant going to the victim's home and shooting a number of rounds into the guy's house. Now, he did this with a revolver. When he was subsequently picked up by the police, they found in his vehicle not only the revolver that he used to shoot at the defendant's house, they also found a 1911, and they found an AR-15. More importantly, the AR-15 was in its original configuration as God intended it to look like. It had a traditional magazine release, it had a pistol grip, it had a flash suppressor, all of the evil features that California is completely antagonistic to. So he was charged with a variety of crimes and found guilty on a variety of crimes. One of them included a violation of California Penal Code Section 3605, which specifically relates to possession of an AR-15, possession of an assault weapon that has not been rendered California compliant. And for a weapon to be rendered California compliant, it has to have either a fixed magazine that requires an actual disassembly of the action to remove the magazine, or alternatively, it cannot have any evil features like a telescoping stock, a pistol grip that protrudes conspicuously below the action, a flash suppressor, or vertical stabilizer. Well, evidently, Mr. Bocanegra, his AR-15 had all of these features, so he was prosecuted under that. After his conviction, he appealed the conviction as it relates specifically to the AR-15, claiming, rightly I believe, that in a post-New York State Rifle and Pistol Association v. Bruin world, now that we have the Bruin test, this statute is unconstitutional. Well, the judge did not like that argument. In fact, he went through a pretty interesting analysis, and in that analysis, he said three things, two of which are unbelievably ridiculous. But then the last thing he said, interestingly enough, can have some greater implications that I'm sure the judge had not originally envisioned. The first thing that he said was that in this particular case, the Second Amendment simply doesn't apply. He said, we always have to do this common use test that was originally articulated in Heller. Are these guns currently in common use? And he said, well, in California, they are not in common use. There's not a lot of people who own AR-15s. He doesn't cite any data to support this contention. And those of us that, are in the Second Amendment community, we know that this is this is a bald-faced lie. I mean, there are a ton of people in California that own AR-15s. Now, he does make the distinction. He says, look, there may be a lot of AR-15s out in the United States, but in California, there's really not that many. What I think he was trying to articulate, although he didn't do it, but what I think he was trying to articulate is that there are not a lot of AR-15s that have not been rendered California compliant. Again, I don't know where he gets this data from, but nonetheless, he makes that statement. Okay, so we can dismiss that. Then he ends up bifurcating the common use test. And this is something that I've seen a number of courts do. And frankly, they're just flat out wrong about it. They say that the Second Amendment only protects weapons that are in common use for the purposes of self-defense. And they take this from Heller versus the District of Columbia. That is not an accurate reading of what Heller said. What Heller said was common use for lawful purposes such as self-defense. That's a big distinction, okay? Self-defense is obviously one of the lawful purposes of bearing arms, but there's a ton of other things that we do with firearms that bear no relationship to immediate self-defense. Everything from shooting at the range or, displaying our firearms. There's a number of things that we do that are not for the immediacy of self-defense. So he says that since this firearm is not being used exclusively for self-defense, it falls outside the scope of the Second Amendment. Then he says something very, very interesting. And like I said, I think this may be the thing that the California legislature is not going to be too terribly happy about. He said that in this particular instance, Mr. Bocanegra was using the firearm in an illegal manner. Now, that in and of itself is problematic because the facts show that he actually wasn't using that gun to commit the crimes. But that all notwithstanding, he says that he was using the gun in an illegal manner. And since it was being used in a illegal manner, it's not covered by the Second Amendment. Well, if that part of the opinion ultimately holds on a reversal, which I think it's probably going to be reversed ultimately, that becomes really problematic for the California legislature. Essentially, what he's done is taken a round peg and very forcibly inserted it into a square hole. He was able to do it, but it's ugly, the final results that he ultimately comes up with. If we were to use this analysis, we could effectively sit there and say, if you have an AR-15 and you are using it in a legal manner, then therefore you would be falling within the scope of the Second Amendment. Since you're now within the scope of the Second Amendment, we move into the Bruin analysis where the state has to show that their regulations, specifically the regulations that prevent you from having a collapsible stock and a pistol grip and a flash suppressor, are consistent with the firearms regulations that existed at the time of the ratification. Well, they're not going to be able to do that. The only way that this judge is essentially saying the statute can stay is if it is only put upon people that are using their weapons in an illegal manner. All right, so effectively, Section 3605 becomes nothing more than a gun enhancement. So if you think about somebody robbing a liquor store, okay, they can be charged with robbery. That's the predicate crime. The enhancement to that predicate crime is put into play when they use a firearm to commit the crime. So if we look at it that way, then law-abiding citizens are essentially exempt from California's law relating to AR-15s. Now, I'm sure this is not what the judge was trying to get across with his opinion. But, Justice Oliver Wendell Holmes had a famous saying that hard cases make bad law. In this particular instance, it's a hard case. I mean, this defendant is not exactly a choir boy here by any stretch of the imagination. But in the judge's attempt to keep the conviction in place, what he's effectively done, inadvertently, I believe, is give us a lot more potential freedom. Anyways, like I said, I think this case is probably going to be appealed again. We'll have to see what happens. Of course, there are other cases that could directly affect this as well. The most important two are both Rupp v. Bonta, which is currently going before the Ninth Circuit Court of Appeals, which challenges the assault weapons restrictions in California, and a companion case directly behind it called Miller v. Bonta. So I definitely encourage you to pay attention to all these things. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe. And if for ever any reason you need to contact me, always feel free to do so at my email at steven@artemishq.com. Thank you very much for watching.
Do you carry with around in the chamber? Because if you don't, you need to watch this video right next to me, because it's dangerous not to, and I'll explain why. Yes, you should carry with one in the chamber.